Hi everyone, welcome to the latest edition of the Financial Planner. I hope you're all safe and well. And in particular to this Tuesday's educational slot, which as you know is going to focus on wills and probate. Now, this is a big issue for us in terms of how we help people plan. Our very strapline, if you like, for today and tomorrow is all about, of course, savings, investments, looking to plan for the future. But at the very core of what people should be doing, following on from my video on Friday about protection, life cover, critical illness cover, is protecting you, yourself, your loved ones, and making sure that you've basically got everything in order should anything happen to you. Now again, not the happiest of topics, but clearly something which we all should take time to do. The statistics in the UK are dreadful still in terms of who actually has a will or has an up-to-date will, one that's relevant to their current circumstances, and even worse when it comes to people who either understand or have in place powers of attorney. Now, Charlotte Vanderway, who heads up the Wills and Probate Department at Oakwood Solicitors in Leeds, has very kindly agreed, if not somewhat nervous, to do a question and answer session with us, and is going to cover off some of the basics. It's impossible to cover off everybody's individual questions, but Charlotte's very kindly going to take any of those questions that you forward back to us, and instructions will be on this email of how you can do that, and she will liaise with you directly with specific answers to your own circumstances if that's required. I think from our perspective, if nothing else, and we keep stressing this kind of element of downtime from this stay-at-home kind of mentality, has to be to put some of these things in place and get yourself and your affairs in order. So please do listen keenly, write down any questions you've got, and I hope this is of some use. Right then, Charlotte, let's start with the first, I guess, generic but very popular asked question, which is as follows on screen. Can you remind everyone the key reason why having an up-to-date will is so important, first and foremost, and what the pitfalls and implications would be of dying intestate?
Thank you, Rob. It is important to address these issues at this time, in particular when our personal situations are constantly changing, whether it be the start of a new relationship, the end of an old relationship, having children, the purchase of a new property, the loss of a close one, or indeed a change in our financial situations. When any of these changes affect our personal lives, it's important to review the terms of our wills to make sure that they reflect our current circumstances. Now, each time our circumstances change, we try and encourage our clients to review their wills and consider whether they need updating. You mentioned passing away intestate. Well, this is important to consider this, because if we don't have a will, then our estate effectively passes under what is known as the intestacy rules. These are legal rules which stipulate who gets what from your estate. So if you're married, then your spouse or civil partner would receive your estate. If you're married with children, then there are rules governing how your estate is distributed. So it's important to think about whether this is how you would want your estate to pass on your death without having a will. There are further complications. If you're not married but living with a partner, there's no automatic entitlement for your partner to receive any assets under your will. If you're separated from a spouse or your civil partner but not having the divorce or the dissolution of a civil partnership finalised, and then you pass away, they will still inherit under the terms of the intestacy rules. My suggestions would be to ensure that your estate passes to who you want it to pass to. It would be beneficial to write a will and you make the decisions as to where your estate goes upon your death.
Great, Charlotte, thanks for that. I think you make some hugely valid points there. I think people's circumstances have changed since a lot of people first looked at the will, if they've even made one at all, and it's imperative now that you stop telling yourself that we must do this, we must do that, we must reflect the fact that there are now different facets to my needs and requirements, or I've got different parts to the family who I'd now gift to differently. You're in control of this, of course, so therefore you can't make these decisions post a situation happening, so please do actively take time to address it now. So on to the second question, Charlotte, please, on screen now. What would you say to people watching this video who are concerned their current will might be out of date? or need alterations? Can an old will be easily amended, or is it often better to start from scratch? And why would you suggest that if that's the case?
It is straightforward, Rob, to update a will, and we offer a free will review so that we can meet with clients, look through their wills that they currently have, discuss with them their current situation, and then assess whether or not the will meets their current requirements. If a will does meet the client's current requirements, it doesn't matter how old the will is, then it will be fine and there's no need to update it. If the will no longer meets the client's requirements, then we will take steps to consider updating the will. Now, a simple update could be done by making a codicil. This is an additional document to the will, which will effectively change certain provisions in the will. This is if it's straightforward. If it's more complex, then we would suggest making a new will. And we would discuss this with the client and ensure that any changes, whether they're complex changes by the inclusion of a trust, or whether we're making big changes by taking people out of a will, we would ensure that the client is happy with making a new will, which would then supersede the previous will.
Great, Charlotte, thanks for that. I think the points to take from that for me is I get often asked, do we have to completely start again? Can we scrap our will completely? Is there a time scale to how long a will lasts? Can it just make simple amends, etc.? So I think Charlotte's offered a little bit of clarity there, but I guess it depends on the size of the changes, the implications of what you're looking to make there, and therefore that's maybe where you redirect a personal question to Charlotte if that helps with regards to asking anything specifically about your own household affairs. Moving on then, please, on screen now. Question number 3, Charlotte, if you could answer this for me, please, would be, why would you advise people to take professional advice as opposed to using a cheap online offering and creating their own documentation? Conscious of this at the minute because, of course, it's become a growing kind of push in the general media to suggest that everyone can do everything themselves. And of course, in certain situations, I guess you can take your own instruction and effectively implement things by a Google search, for want of a better word, and effectively looking to implement this yourself. I'm a huge fan of using the analogy of the reason why I don't fit my own bathroom is the fact that it would leak, and therefore I'm not a big fan of people taking on things that can be a little bit more complex. And they absolutely, you can't afford any error here. You need it to be absolutely correct. So can you just clarify those points in your opinion around that to maybe give people a little bit more guidance?
Yes, Rob, you may have seen that there has been an increase of will writing services online trying to promote the preparation of a will which is easier, quicker, and without the requirement of using a solicitor. Now, we're not saying that this is wrong. This may be perfectly acceptable for clients who have straightforward, simple wills. Now, anything more complex, it may well be beneficial to seek advice from a solicitor. Solicitors' fees are not always very high for the preparation of a will. We offer a fixed fee will writing service, and this would be something that the majority of solicitors would also do. This means that we're transparent with our fees, as we are required to be by the Solicitors Regulatory Authority, and we are under a duty to ensure that our clients are abreast of the fees throughout the will writing process. So if instructions change from the initial meeting, then of course there may be an additional fee if the matter becomes more complex. Now, as also by being regulated by the Solicitors Regulatory Authority, we are under a duty of care to our clients, and this then gives the client the confidence that we are dealing with their wills, we're professionals, and if anything goes wrong, there is comeback, and it offers protection to the client. Now, the usual process, obviously it's not going to be online, so usual process is to meet our clients face to face. We get the full picture of our client's circumstances. We take their instructions of what they want to include in their wills, and then we go away and prepare a draft of their wills. We will then follow up with a meeting to go through that will with the client, to ensure that they understand, to ensure that it meets with their instructions and their personal circumstances. And we can make any changes that are necessary with the client's full understanding all the way through. And then when it comes to signing the wills, we're there to supervise the signing. And once again, to ensure that they are fully in agreement with the terms of their will, as we always ensure that our client is happy with their will before it's signed. And so the client is confident that their instructions have been carried out, their will reflects their personal circumstances, and that they know that we have provided them with the relevant advice.
Great, thanks Charlotte. Don't worry, I think you went through that superbly well. I think it's difficult. Charlotte's not done these type of videos before, so I hope you appreciated her input there. And I know she will feel, like I've stressed many times before, more than comfortable to answer any individual questions that you've got. Following on from this, and next week we're then going to cover off in part 2 powers of attorney, and I think that's really relevant for a lot of you listening. You might have your will in place and this has just reaffirmed what you have that is correct. But powers of attorney, of course, and the idea of capacity, and using my video on Friday about the fact of what I went through and my illness in Abu Dhabi, then ultimately if I'd have lost mental capacity, would I have been able to felt assured that my wife could have picked up the pieces, controlled all of my affairs, regardless of the fact that we've been married for such a long time? Could she have actually had access to things in my own name? And the quite worrying answer would have been no, if we hadn't had a power of attorney in place. So we're going to pick up on that next week, so please do follow us up and watch the follow-up video. But again, from me today, stay safe. Thanks very much for your continued support and input, and we very much look forward to catching up with you soon.